In the Philippine legal system, public protest occupies a crucial space between constitutional liberty and police authority. The 1987 Constitution, under Article 3, Section 4, guarantees freedom of speech, of expression, and of peaceful assembly. This right exists not as a mere concession from government, but as a foundational element of democratic participation. The framers of the Constitution envisioned a society where dissent is not only tolerated but recognized as essential to accountability. Yet, the same legal framework acknowledges that rights coexist with the state's power to maintain peace, safety, and order. This forms the tension that protest law seeks to balance: freedom on one hand, regulation on the other. To understand how this balance is struck, we look first to jurisprudence. In the landmark case of Reyes versus Bagatsing in 1983, the Supreme Court clarified that the requirement of a rally permit is regulatory, not prohibitive. The court held that a permit may only be denied if the government can show a clear and present danger of a substantive evil that it has the right to prevent. This doctrine is significant because it protects assemblies from arbitrary refusal. The burden of proof lies with the state, meaning the default assumption is in favor of allowing the protest unless concrete, serious risks are demonstrated. Speculation, discomfort, or fear of criticism is insufficient. Years later, the court revisited protest regulation in Bayan Muna versus Ermita, decided in 2006. The controversy centered on Batas Pambansa, BLG 880, also known as the Public Assembly Act of 1985. Critics argued that the law restricted liberty. The court, however, upheld it as a valid time, place, and manner regulation. The ruling stressed that the Constitution allows reasonable regulation of the streets, provided that such regulation is content neutral. In simpler terms, the state may regulate where and how a protest occurs, but not the message it expresses. The court emphasized the policy of maximum tolerance, requiring law enforcement to prioritize restraint over confrontation. Another jurisprudential pillar is Iglesia ni Cristo versus Court of Appeals, decided in 1996, which dealt with expression critical of public authority. The ruling affirmed that even speech that provokes dissatisfaction remains constitutionally protected. The decision is a reminder that the right to protest is not contingent on popularity, convenience, or government approval. The essence of free expression lies precisely in the ability to question power. With doctrine established, we now examine statutory structure. The Public Assembly Act defines public assemblies broadly, covering rallies, demonstrations, protests, marches, and pickets. When such activities occur in public spaces, a written permit from the local government is generally required. The law sets procedural guidelines. Organizers must file an application, specify date, time, route, and estimated participants. The mayor, upon receiving the application, must act promptly. Disapproval must be justified in writing on grounds consistent with the clear and present danger test. Silence or inaction may be construed as approval. However, the law also recognizes real-world urgency. Spontaneous assembly is allowed when events of great national significance unfold and time does not permit formal permit processing. In such cases, maximum tolerance still governs police response. The doctrine acknowledges that protest is sometimes reactive, emotional, and immediate. Police powers arise from the inherent authority of the state to protect public welfare. During protests, police may enforce crowd control, redirect traffic, set perimeters, inspect materials for safety, and mediate between groups. This authority is not unlimited. It must be exercised reasonably, proportionately, and with respect for constitutional rights. Force may only be used when strictly necessary, such as when a protest becomes violent or threatens lives or property. Even then, force must follow a graduated scale. Verbal warnings, negotiation, nonviolent methods, and only as a last resort, physical intervention. A common question is whether lack of a permit automatically justifies dispersal or arrest. Jurisprudence suggests otherwise. If the gathering remains peaceful and does not obstruct public rights excessively, immediate dispersal may be disproportionate. The purpose of regulation is not to prevent dissent but to coordinate it. Arrest may be lawful only when participants engage in violence, refuse to obey lawful orders, or commit defined offenses such as obstruction of public ways or direct assault under Article 151 of the Revised Penal Code. For protesters, understanding rights is crucial. Participants have the right to peaceful assembly, the right against unreasonable searches and seizures, and the right to counsel when arrested or detained. Documentation plays an important role, recording police interactions, noting badge numbers, and collecting witness accounts. Marshals within rallies can maintain order, guide movement, and liaise with police. These measures demonstrate responsibility and help prevent escalation. For police officers, professional duty requires balancing enforcement with restraint. Maximum tolerance does not mean passive allowance of chaos. Rather, it means that public order is preserved through communication and de-escalation, rather than immediate force. Officers must distinguish between peaceful dissent and unlawful aggression. A protest critical of government is not an act of hostility. It is a democratic expression protected by the very Constitution officers are sworn to uphold. This broader framework shows that protest is not merely a street event. It is a legal process shaped by doctrine, policy, and civic culture. When authorities respect rights and protesters respect public order, assemblies become a venue for discussion, solidarity, and reform. They give voice to grievances that formal institutions may overlook. Throughout history, public assemblies have influenced Philippine politics, from the EDSA uprisings to local sectoral campaigns. Their power lies not in noise alone, but in legitimacy rooted in rights. Ultimately, Philippine protest law teaches us that democracy is not quiet. It speaks through megaphones, banners, marches, and chants. The law does not silence it. The law shapes its space. The Constitution protects expression, jurisprudence refines boundaries, and police power ensures that liberty coexists with safety. The challenge for society is to maintain this balance. The protester must know the law, and the police must respect it. When both sides operate within their legal responsibilities, protest becomes not a disruption of democracy, but a demonstration of democracy in motion.